Good afternoon, everybody, and happy 2019. I trust Santa Claus was good to everybody this holiday season. At least I hope so. Hopefully not too many people were naughty. Last year, we largely dedicated a year's worth of seminars to the PDRS and the AMA guides. For those of you who missed these, be sure to check out the recorded copies on our website. For 2019, we're going to explore another topic, discovery. This is a huge topic, maybe larger than you might otherwise think, and it'll be spread over several webinars. I think and I hope you'll find them of interest and value to you. Just some of the topics we'll explore today and in future seminars include attorney fees. What exactly is an applicant's attorney worth? I suspect they think they're worth more than we do. Pre and post application discovery options, sub rosa, witness statements taken by a private investigator and or the adjuster versus those taken by an attorney, deposition rights, timing of the service of private investigator reports, the timing of the service of sub rosa films. Do you really have to serve those? Can you use them and wait for impeachment value at the trial? Evidentiary rules, privileges such as the attorney-client privilege and spousal privilege, subpoena ducus tecums, motions to quash subpoenas, whether you as the adjuster can be subpoenaed to a deposition or trial. What about witnesses who plead the fifth against self-incrimination? Witness fee disputes, preparing for a doctor deposition, and believe it or not, a whole lot more. So it's really going to take most of the year. So buckle up. It's going to be a wild ride. And remember, as Tammy said, if you happen to miss a session or two, you can catch up via links to our website. Not only will these bring you up to speed, they'll also allow you to collect additional continuing education credits. So without further ado, let's get started. You're on notice. You've received a claim form. Probably did it today and yesterday. What do you have to do? Well, hopefully we all know that. We've got the note letter. We got to accept and deny within 90 days, calculate the A to WW, start PD in the next couple of weeks, determine whether there is mod alt available. So there's a lot to learn here. What do you have to investigate in that first 90 days and perhaps thereafter? You've got to do a lot of work. In fact, it's your job, it's your duty to determine liability and must, quote unquote, act with expedition. Or also known as a reasonable and timely investigation. Got to obtain information needed to determine and timely provide each benefit, which, if any. This is the more interesting part. We can't restrict our investigation to preparing for objections or defenses. Oftentimes we get focused on what it is we need to disprove a claim, but we're required to, quote, fully and fairly gather the pertinent information. I leave it to you to define those terms. This last sentence here is interesting. And the claimant's burden of proof does not excuse the administrator's duty to investigate the claim. So although the applicant may have to prove A, B, and C, we have to investigate A through Z. And we are not allowed to restrict our investigation to specific benefits. So if the applicant is currently claiming TD, we need to investigate absolutely everything else to determine if there are other benefits that may be due. If moving along, we think that we've completed our discovery, let's say we did it all within the first 90 days, and the denial or the acceptance has been decided, and suddenly some additional information has come available. Sadly, we can't stick our head in the sand like the ostrich. We must go ahead and do additional discovery. So I think that underscores why these sessions on discovery are so important. You simply need to be involved in discovery from day one to the last day of you handle the case in all likelihood. And for obey purposes, we hope that you document all the efforts undertaken. And I love this. You shall deal fairly and in good faith with all claimants. Play fair, I guess. So what happens if we fail to make a reasonable and timely investigation? The WCAB can do some damage to us. They can make an adverse inference in favor of the applicant. What exactly does that mean? Well, we've got the Hughes aircraft. By the way, that is a Hughes helicopter. You've got the Zamarek case. In this matter, there was an allegation of a psych injury arising out of exposure to certain chemicals. Now, as suggested by the regulations that we just went over, the employer had a duty to investigate and to provide the material safety data sheets, something which the employer failed to do. And it was held that the applicant was exposed to the toxic chemicals. The applicant didn't prove that he was exposed to toxic chemicals, but nevertheless, because the employer failed to do the investigation and provide the MSDS, it was held that pro forma, they were exposed to the chemicals, and this contributed to the injury AOE COE. In other words, there was an adverse inference. Don't rely on this, but there are cases to the contrary. And I think you're going to find out through all of our presentations over the next several sessions that you're going to find case law to the contrary, one way or the other. We don't want to rely on that, but I want to go over the pros and cons, the contra cases, just so that you know when you're behind the 8 ball and perhaps are in trouble for something that we did or didn't do, that there may be case law to support our position. In this case, we've got the Hamilton versus WCAB. By the way, if you haven't seen Hamilton, go see the play. It's amazing. There was an allegation of multiple sclerosis from exposure. And again, like the Hughes case, the employer did not provide the material safety data sheets. But in this case, for some reason, they said, well, it's up to the employee to prove they needed that additional information, which is interesting. It is an interesting burden on the applicant. Query how the applicant is going to be able to prove they needed the sheets without knowing what is on the sheets. Presumably, the WCAB was looking to applicant or applicant's counsel to have a doctor say they need that information. And I suspect that's what happened here. I think that applicant's counsel just dropped the ball on this matter. All the more reason for us not to rely on this case. Nevertheless, in this case, the WCAB found that there was no adverse inference. And in this case, they relied on the evidence code, which is interesting. As we're going to learn in short order, we don't rely on the evidence code, or we do as a general guidance, but it's not mandatory for at least the vast majority of evidentiary issues in workers' compensation. Nevertheless, in this case, they used the evidence code and both the evidence code and case law against applicant, noting that the evidence code does not require an adverse inference to be made on an ultimate issue such as causation. Again, don't rely on this. Just assume that we need to conduct our discovery and provide the information that we're required to provide. Clearly, the judge you draw and the WCAB panel you draw will make all the difference in the world. So, what is our discovery guided by? Well, the appeals board can make up the rules, and they do. The CCP, the California Code of Civil Procedure, as I suggested earlier, is instructive but not mandatory. The WCAB, as hopefully you know, has all of its own rules, and that's via case law and regulations and labor code. So we need to be aware of all three. So what is discovery exactly? This is what we're going to be talking about. It's what we do to learn or create evidence to prove or disprove a case. And of course, as suggested earlier, to provide appropriate benefits. What are some of the discovery tools that we're going to be going over? Well, first off, the mandatory application and answer, which provide us a map of exactly what is that issue, what's admitted, and what we need to explore in our discovery efforts. 5500 notes that the only formal pleadings we have to file are applications and answers. So we're not exactly overloaded with filings that we have to do. If any of you have listened to my presentation on affirmative defenses, you'll remember how important it really is to file an answer. I know many of us often forget to file an answer, but both the labor code and regulations say that if we fail to file a timely answer, we have waived our affirmative defenses. That'll be up to the judge. It's up to the judge's discretion as to whether we've waived the defenses. But I don't think you want to gamble on a judge looking kindly upon the fact that we fail to file an answer in timely fashion. By the way, sometimes I hear folks say, well, I don't know what information I need to file an answer, so I'm going to wait until I file it later on. And then, of course, later on comes along and they forget to file the answer. Waiting until you have the full information is really actually kind of silly, because you can amend your answer as many times as you want, and you're probably not even going to do that. You're probably going to file your answer, stop the statute of limitations from running, and work from there. So discovery toolings include, we just said, the application and the DOR. I'm sorry, strike that, the application and the answer. And they also include the subpoena of witnesses and documents, something we're going to go over in great detail either this webinar or the next. Deposition of witnesses, we're going to go over in great detail as well. Of course, we're all familiar with Labor Code Section 5710, which provides that we can take depositions, or the appeals board can cause deposition of witnesses residing within or without the state. And you might say, well, wait a minute, does the WCIB have jurisdiction to force a party or a witness to have their deposition taken out of state? And the answer to that is no, but we can certainly ask pretty please to have that taken place. The deponent, hopefully we are aware of this, is entitled to transportation, meals, and lodging necessary for the deposition. Rarely a case, but if they've moved out of state, that can be something we have to provide. Lost wages occurring during the attendance of the deposition. Of course, if they're collecting TD, that's something we don't have to worry about. A transcript, or a copy of the transcript anyway, and reasonable attorney's fees. What's reasonable? Well, I guess that depends on who you ask. I suspect the number that I believe is reasonable is probably something less than our friends at the California Applicants Attorneys Association. We're going to go over that in great detail. Probably not this session, but the next session. I think you're going to find that fascinating. I know I did when I researched this. And of course, finally, the interpreter's fees, which we have guides for in terms of what is and is not reasonable. What other discovery tools are included? Well, the examination of and copying of hospital and physician records that are relevant. Hit the word relevant. That's the code word for anything and everything we do. We can't do anything that's not relevant. We can pretty much do anything that is relevant unless there's a special rule precluding it, including the examining and copying of hospital records. Subject to Labor Code Section 3762, whatever that means. We're going to talk about that in just a few seconds. And except as otherwise provided by law, we'll get that in later sessions. All parties are entitled to examine and make copies, in short, probably subpoena, records that are, well, there's our magic word, relevant. What about 3762? What does that say? Well, except as provided in the next two sessions, sections that we're going to, or subdivisions we're going to take a look at, the insurer shall discuss all elements of a claim with the employer that affect the employer's premium, and supply copies of documents that affect the premium. Well, as close as I can guess here, everything, virtually anything and everything, and in fact, off the top of my head, I can't think of anything involving a claim that doesn't affect the employer's premium. If you can think of something, please email that to me. Nevertheless, we are not allowed to provide the employer with everything. There are these specific exceptions. We shall not allow, first off, if there's an attorney-client privilege involved, we can refuse to provide the employer that information, that or any other applicable privilege, easy for me to say, or prohibition, but perhaps more importantly, the insurance or third-party administrator is prohibited from providing or disclosing any medical information about the employee. And you know what? As an employer, I don't want to know medical information about my employee. I can only get in trouble for that via FEHA, ADA, workers' compensation, discrimination, what have you. Anyway, the third party, the TPA and insurer, are prohibited from disclosing or causing to be disclosed to the employer any medical information except that which was claimed. Okay, so they filed a site claim on the DWC-1 claim form. Well, employer, they filed a site claim. And the treatment provided for that, not the treatment records, but that the receiving treatment from Dr. XYZ, and medical information necessary for the employer to provide modified work duties. Again, that doesn't mean we provide the employer with the doctor's reports. We can simply say the doctor has said no heavy lifting, repetitive bending, and stooping, or what have you. Now, I know this provision drives some employers absolutely crazy, many of them will be made very unhappy by this. But failure to follow these rules may very well subject you to civil action. What other discovery tools are we going to talk about? Exhumation and autopsies for industrially related deaths. This actually provided in the labor code that we can require, or the WCAB can require an autopsy. Any party can be allowed to attend an autopsy, and this is interesting. If the body is already in the ground and the dependents, or the majority of them anyway, don't want the autopsy performed, we now have a presumption in our favor. It is presumed, although it's a disputable presumption, it is presumed that the injury or death was not work-related. So somebody is dead, there's an accusation or claim that it was work-related, and they're in the ground, and the dependents don't want us to take that body out, we're probably going to defeat the case. Query what happens when the body is cremated. I've actually not seen that situation. If any of you have, I'd love to hear about it. Presumably, if there's already been a demand for the body before the cremation, the same situation is going to be here. If they proceed with the cremation, there's going to be a disputable presumption that the injury/death was not AOE/COE. All right, that's a lot of discovery tools. If you believe that's not enough, you may be unlucky. That's kind of tough. The labor code is very vague as to what we're going to be provided. We are provided discovery tools to accomplish quote unquote substantial justice as required by the Constitution. Sometimes folks are surprised to find out that our jobs, workers' compensation, are based not exclusively or only on the labor code and regulations, but the California Constitution requires that we have a workers' compensation system. In short, our jobs are safe for the most part, unless and until we have a constitutional amendment getting rid of workers' compensation. Makes me feel a little safer about my work. The Constitution, it says about workers' compensation, it shall accomplish substantial justice in all cases expeditiously, inexpensively, and without encumbrance of any character. Interestingly, that phrase is bandied about a great deal in a number of cases and relied upon in helping determine how a decision is going to be made in the case law. And we'll touch upon that as well during our various sessions. Similarly with this, we'll similarly be banning this about. The discovery will be allowed, quote, in the manner which is best calculated to ascertain the substantial rights of the parties and carry out the spirit and provisions of the Workers' Compensation Act. This tends to go both ways. sometimes if the judge wants to find that the discovery should be allowed, they'll say, well, we're ascertaining the substantial rights. If the judge doesn't want to allow the discovery to proceed, they'll say, well, you're supposed to do this expeditiously and inexpensively rather, and to allow this discovery procedure that you, the applicant, or you, the defendant, are trying to be allowed to do will delay things or cause them to become more expensive. So these phrases here can be used to cut both ways. So the big picture, you've got the claim form filed, you've got the 90 days to accept or deny. What do? You conduct your discovery immediately, or sooner if at all possible. What kind of discovery? Well, at that point, it's fairly limited. Because what kind of discovery is started? Why is it started? Or I'm striking that. Why is it limited when just the DWC-1 claim form has been filed? Well, we don't have jurisdiction. WCAB jurisdiction is necessary to file a subpoena and command the performance of the provision of records or attendance of a deposition. If we don't have an application, we are very much limited. The DWC-1 claim form does not get us WCAB jurisdiction. So what types of discovery can we get before the claim form is filed? And I want to do a little aside here. Those of you who have been doing workers' compensation way too long, like me, remember the bad old days when we couldn't file an application. If we had a pro per and we ended up filing an application, the pro per would obtain an attorney, or could obtain an attorney, who worked at an hourly rate that came out of our pocket and not simply for a percentage of 12 to 15% out of the final award. That's no longer the case. We can file an application for adjudication that permits us to grant or obtain the WCAB's jurisdiction, and thereby allowing us to conduct forced discovery without that concern. That they've changed the law in the second to last reform, I believe. So what can we do? By the way, for those who've been doing this way too long, we had the window period in 1990 to 1993. Just ignore that. Unless you've got a case during those dates and are conducting discovery, in which case, give me a call and I'll laugh at you and try to help you through. So accepting that, if the WCAB has no pre-application jurisdiction over a claim, that is, if it's just the DWC-1 claim and no application has been filed, the WCAB can't force things to be done, can't compel things, that is. In the pre-app, you can't notice or compel a deposition, you can't subpoena witnesses, you can't subpoena medical records or employment records or any other records of any kind. And if there is a problem of a pro per arising pre-app, the judge may refer the applicant to the INA officer, of course. Hopefully, they'll help them file an application if you're not so inclined. Non-compelled pre-app actions that we can do, we can request that the applicant attend an exam by a QME. We can request that they execute a release for medical records, but that's under the pretty please category. Please do it, please do it. We can't force their hand. We can request that they provide various records, such as wage information, but we can't force their hand. And we can interview the injured employee or other potential witnesses. But again, pretty please, we can't force their hand. Sub rosa, we can conduct without an application. And remember, he can get no order compelling until the application is filed. Trying to compel discovery without an application on file is a bad thing. You will be considered very naughty. And we don't want to do it because the punishments are fairly severe. Once the application is filed, if the judge discovers that we've conducted supposedly compelled discovery prior to the application being filed, he or she can sanction financial sanctions for noticing the depot, subpoenaing a witness to a depot, subpoenaing medical records or documents, etc. Can have evidentiary sanctions. This is probably the worst one, by excluding improperly discovered material. So you took their supposed deposition, you got great information. Not only may the information from the deposition be stricken and you can't use it, but any discovery that you were able to find as a result of that supposed deposition, you may be stricken and you might not be able to use it. So for example, so you claim you're taking their deposition, you notice a deposition, you invoke the WCAB's non-existing jurisdiction, you proceed with this supposed deposition, and you find out all sorts of juicy details about the applicant and places that records that need to be subpoenaed, say hospital X, Y, and Z, and doctor 1, 2, and 3, and you proceed to subpoena those 3 or those 6 facilities. The judge may exclude all the information that you obtained in the deposition and all those resulting subpoenaed records, sort of a fruit of the poisonous tree theory. There are also additional financial sanctions for breaching the duty to file the application and penalties for delays and benefits because, well, strike that. And if an applicant's attorney has to be involved as a result of your conducting compelled discovery without incurring or using the WCAB's proper jurisdiction, we may get stuck with their hourly rates as well. If we looked at some regulations in labor code in terms of discovery, what are some of the judge-created methods? Well, witness statements taken during the investigation, which may or may not be discoverable. Well, strike that. They're discoverable. The only question is, when may they be discoverable? At least some of them are. Entitled to have an expert inspect the employer's premises. There's a case directly on point, which we'll talk about shortly. Sub rosa, we're going to talk about that next session or in 2 sessions, if created without fraudulent inducement. There's our investigator. And remember, there are many other, there are many discovery methods provided by the CCCP, the California Code of Civil Procedure, that again don't apply to workers' compensation. That having been said, if there is a type of discovery in the CCP that you want to utilize, it doesn't mean you can't. You're just going to have to get the WCJ's okay on it, or at least have to argue vehemently to get it into evidence when applicant's counsel objects and says that you did not obtain that information pursuant to the generally accepted discovery tools in workers' compensation. Be ready to argue. Here's an example. In civil actions, interrogatories are regularly used. One party sends the other party a list of questions. They answer the questions and send them back under penalty of perjury, something like Trump was just requested to do. And this avoids, or this either avoids depositions or helps cut down on the length of depositions necessary. We can find out their full name, their full address, where they've lived previously, their places of employment, etc. And they don't have to go over this in the deposition. So it's more expeditious and definitely far more economical. There's been some exploration as to whether interrogatories are permissible in workers' compensation. In the Smith case, it was held in 2013 that the WCAB may refuse to allow them. And truth be told, the WCAB can pretty much refuse to allow most anything. However, we've also got the Lubin case in which just the opposite was held. It said in these rare instances, written interrogatories may be the only practical way to obtain discovery. So, if so, they should be brief. Well, I don't know about that. Should call for specific factual information and not legal conclusions. Well, that's true of the deposition as well, so that's not really a big detail, and should not be unduly burdensome. Once again, that's true of depositions, and so that's not really a big detail. Not surprisingly, the parties may agree to written interrogatories, and I think that's going to happen when the applicant is on the other side of the country or is in prison. In fact, there's a case in which an applicant was in prison, and actually, here we go, Pleasant Valley State Prison, Nady versus the prison. In this case, the defendant sought interrogatories, and in that case, the judge said that there are less cumbersome discovery methods. Huh? What, we're going to take a deposition down at the state prison? Now that sounds expeditious, non-economical, cumbersome. And the WCAB said, no, in a panel decision anyway, no, the judge was in error and the written inquiries, the interrogatories were appropriate. So this is kind of a big deal if you think about it. You may want to consider using interrogatories a little bit more often, either to the exclusion of depositions, which of course require 5710 fees, the TD payment, the court reporter, the defense attorney costs, etc. So either in lieu of the deposition or in preparation for the deposition, so that the expensive deposition exercise, the length of it can be mitigated and thus your costs can be mitigated. So save time, save money. It is a big deal. So what are the bright line rules as to what is and isn't appropriate discovery? Well, there aren't any. The WCAB, as I suggested earlier, is not bound by the CCP, nor the common law, nor statutory rules. This is also one of those funky little wishy-washy statements. The WCAB may allow discovery which is best calculated to ascertain substantial rights and carry out justly the spirit and provisions of workers' compensation. I don't know what the spirit of the provisions of workers' compensation is. It really depends on the reader. Some judges will tell you, well, it's in order to expeditiously provide benefits to an applicant, which it is. Other judges will focus more on the fact that it's at least partially aimed at avoiding fraud, which it is. So it's a weighing of the competing interests, and in that way judges can go both ways, and that's why I suggested earlier we're going to go over as we go over case law, we'll often find cases that came up with exactly the opposite conclusion. Things are very informal. Anybody who's met me knows how informal I am. Despite informalities, that will not invalidate any decisions, and the evidence code is not applicable, nor the CCP. Just because we've conducted some discovery or there's been an order award and it didn't follow the CCP or doesn't mean that it's going to be invalidated. So informality is just fine. Even the California Supreme Court has weighed in on this, in particular on hearsay. By the way, here people often say, well, that's hearsay, this is hearsay. And oftentimes they're using the wrong definition. Learned this in law school at UCLA 1 trillion years ago. Hearsay is an out-of-court statement used to prove the truth of the statement. For example, an individual tells another individual that the truck was out of the court was going about 45 miles an hour. Well, if that's offered into court, that is, in all likelihood, it is an out-of-court statement being offered to prove that the truck was going 45 miles an hour. So that is hearsay. If an applicant or if an individual on the other side says out of court, I am Napoleon, and that's offered into court as evidence, that's not hearsay because it's not being offered to prove that he is Napoleon, unless it's very long ago and he was wearing an interesting uniform and had his hand in his shirt like Napoleon always did. That is not hearsay. Nevertheless, the point here in the Supreme Court decision was hearsay is okay because we're simply less stringent and much more informal in workers' compensation. Let's read actually what the WCIB says on that. Liberal pretrial discovery, I read that as letting us do as much as we can reasonably do to obtain relevant information. Liberal pretrial discovery is desirable and beneficial for ascertaining the truth. We're all good with that. Preventing perjury. We're all good with that. Detecting and exposing false and fraudulent and sham claims. Absolutely. And making available inexpensive facts and encouraging settlement along the way by avoiding and safeguarding against surprise. That safeguarding against surprise phrase is a big deal because it's often bandied about when we're talking about when and where discovery has to be made available to the opposing side, such as witness statements or more obviously private attorney sub rosa and reports issued by the private attorney or the PI rather, the private investigator. When does the film, for example, have to be revealed? That's a big deal, and we will go over that in great deal as well. What if the judge is wavering, can't quite decide which way to go? Its relevancy is going to decide the issue. By the way, in case you're wondering what that picture is, it's a balancing act. There are a number of pictures in here that I put in and I thought they were relevant, and then I realized later people might not recognize what that's supposed to mean. We can't completely ignore the evidentiary rules, however. For example, if we're relying on X evidence, X evidence must have some probative value. What does that mean? A tendency to prove or disprove one or more of the legal elements of the case, making an element more likely or less likely. In short, tending to prove or disprove an element. If it doesn't prove or disprove something, it's irrelevant, and the judge or applicant's counsel in deposition are going to say that's irrelevant, move on. Rule of thumb, pretrial discovery, whether it's reasonably calculated to lead to discovery of admissible evidence. Reasonable. That word was invented, I think, as a make work project for attorneys everywhere. If we were able to extricate the word reasonable from all our regulations, our labor our codes, and our case law, there would be a lot less work for attorneys. So I'm all for keeping it in there. Express limitations. There are a number of them. In the cases of sexual assault or battery, these are kind of icky cases here. They're going to be restraints on the discovery. For example, we're not allowed to ask about or explore the sexual contact or conduct of the applicant with any person other than the defendant. And prior to this, the argument would be on the defense side, well, this person slept around and they wanted it. Kind of a old-fashioned and not acceptable approach, and that's what the legislature wanted to get rid of here. They were asking for it, I think is what I was trying to go with. Opinion evidence of the reputation and of specific instances of sexual conduct of the applicant with any person other than the defendant, or any evidence not admissible by the defendant to prove consent or absence of injury to the applicant is prohibited. Some of the other express examples of privileges that we will go through in detail: the attorney-client privilege, the physician-patient privilege, HIV/AIDS limits, medical information, as we already talked about, that the insurer TPA can't disclose to the employer. All right, how are we doing here in terms of time? All right, we got about 20 minutes, so we're going pretty well. Witness statements and interviews are permissible even prior to the application for adjudication being filed, because we're not invoking the WCAB's jurisdiction to force the witness to provide a statement, to force the witness to undergo an interview. They are doing so voluntarily. The pros and advantages of taking a statement right away, as their memory is isn't going to get better with time, and if you're doing this within the first 90 days, it's going to help decide whether or not to deny the case and identify fraud. And often in cases, as the different sides sort of group up and decide people who decide which side of the fence, applicant or defense, they're going to work with. Co-employees, for example, may decide that they're going to be on the employer side, that they think the employer is in the right, or their buddy, the applicant, is in the right, and they want to give statements to their benefit. Oftentimes, this happens as the case progresses, but not right away. And so if we take the witness statement immediately or shortly thereafter the alleged injury, we receive, hopefully, a more dispassionate report, a more dispassionate interview statement. Now, investigative statements taken before retaining a DA, as we're just talking about here, there are some potential problems. In fact, some very significant problems. The statements may be discoverable. And if we're claiming work product privilege or attorney-client privilege, that might not apply if these statements were taken prior to an attorney being on the case. There's an absolute privilege if the writing reflects, the report, etc., reflects an attorney's impressions, conclusions, opinions, legal research, or theories. So if the statement in some way reflects this, it doesn't have to expressly state what the attorney's impressions, conclusions, opinions, etc. are. But if you can sort of assess where the attorney is going with the case by reviewing the statement, there's going to be an absolute privilege against having to give that up to the other side. There's a qualified privilege of discovery against the general work product. It's likely discoverable if it doesn't reflect the attorney's impressions, conclusions, opinions, legal research, and legal opinions. So the takeaway, if in doubt, have the attorney take the statement. I understand that we want to expedite things before there's an attorney on board, and we want to do things more inexpensively, and then thus have an investigator or the adjuster take it. And obviously, many, if not most times, that's going to be appropriate. But we need to step back and take a look at the case and see how we estimate it's going to proceed. Is it going to be contentious, for example? If it's going to be contentious and expensive, you may want to get an attorney on the job as soon as possible to take those statements. If possible, avoid recordings, video recordings, audio recordings, papers, computers. Why? You can't subpoena something that has an absolute privilege or that simply doesn't exist. Let me give you an example of using information that doesn't exist or is not in a report. When I'm preparing for a doctor deposition in a big case, a life pension or 100% case, I'm doing workers' compensation for a quarter of a century. I'm pretty good on the workers' compensation rules and laws and case law, and certainly been exposed to a lot of medicine. And Lord knows I love Google because it can provide me a nice update as to what the latest and greatest is on various medical issues and treatment. But I'm not an expert, far from it. And never practiced medicine, didn't go to medical school, don't play a doctor on television. And so in those situations, those really expensive cases, I will go to another doctor, actually in my case, a personal friend who will review the records and whisper in my ear and tell me what I should be asking, what I shouldn't be asking in the deposition. In that case, I expressly tell the doctor, I don't want a report. In fact, do not write a report. We will go over your recommendations over lunch. Why? Because a report may in some way be discoverable, and I don't want to take that chance. Witness statements derived from an attorney interview are protected work product. Again, we talked about the impressions, conclusions, opinions, legal research, and theories. Inextricably interlinked. In short, if you take a look at the statement and in some way, shape, or form, the impressions, conclusions, opinions, or legal research theories are inextricably linked with the work product, this works the defense weapon. We don't have to give up that information. Hallelujah. Take that, Benson. For those of you who are familiar with Benson, you'll understand the reference to Labor Code Section 4664. The Supreme Court has spoken on this, and they said that a recorded interview may be entitled to the absolute protection if they're, as I just said, inextricably linked. And if you're going to have a personal or a private investigator interview somebody, the very fact that the attorney has chosen to interview a particular witness may disclose important or tactical evaluative. Wow, there's a tough one for me. Hey, speaking in tongues. And that alone may preclude this information be discovered. Now, not all statements obtained on behalf of the attorney will, quote unquote, reveal the attorney's thought processes. If, for example, the attorney sends an investigator to conduct the interview and take statements, and the investigator just says what happened, and let the witness proceed, that certainly doesn't reveal any of the attorney's thought processes. Or if the attorney allows the investigator to make up their own questions, that doesn't reveal the attorney's thought processes. So you definitely want the attorney's fingerprints all over the statement to make it privileged. As I just said, a witness statement obtained through an attorney-directed interview is, as a matter of law, entitled to at least qualified work product or protection. So what are the rules here? We want to have the attorney's fingerprints all over the questioning, if not taking the question themselves. So we have the absolute privilege. But if we can't do that, if the attorney has simply directed the interview be taken by an investigator or the adjuster or what have you, there is potentially a qualified work product privilege. Absolute privileges are decided on a case-by-case basis. The opposing party seeking disclosure has to demonstrate that if they don't get that information, it's going to, quote, unfairly prejudice, end of quote, them. And then the party, usually the defense, alleges that the witness statement is absolutely protected and has to make an informal or preliminary foundational showing that it is. You know, I, Don Barthel, the attorney, went ahead and conducted the investigation or took the statement, or I, Don Barthel, spoke with the investigator and provided the investigator with 27 questions, and those 27 questions were relayed as I asked them. And the next step, the trial judge then makes an in-camera inspection, an in-chambers inspection to determine whether a protection shall apply to some or all of the material. If it's determined that it's not absolutely protected, the court then has to decide whether the plaintiff or the party seeking the information can show a fair, unfair prejudice or injustice. The hardest case is the major case, the main case, to tell us what we just stated, that attorney work product does not apply if the information is gathered by the adjuster or investigator who is not an agent of the attorney or who obtained the information before the attorney was retained. Statements taken by a party, agent, or attorney, including those by a PI, should be disclosed. Well, they're going to have to be disclosed if they're not protected by the privilege. That includes not just films, but reports regarding surveillance themselves may need to be turned over. In the Martin case, a couple decades ago, the insurer hired an outside agency at the request of the defense attorney to take the statements of coworkers, supervisors, and based on these statements taken under the direction of the defense attorney, the matter was denied. Applicant, not surprisingly, requested a copy of the investigation, and not surprisingly, the defense said attorney-client privilege, an absolute privilege, and work product privilege, a partial privilege. The first holding, by the WCAB that is, said this is protected by the attorney-client privilege. The District Court of Appeals said no, it's not protected. They said, well, there's many factors in determining whether there is a privilege. Witness statements should be more frequently disclosed in workers' compensation. This is a ruling that really bothers me because it can be used by applicants' attorneys in almost any setting. The applicant's attorney cannot afford to take a deposition of defense witnesses, as there is no provision for deposition fees of witnesses. In addition, to hire an investigator to take their statements would again be expensive. So this is used as a weapon against us to pry our hands open and allow applicants' counsel to get their hand on work product that's not fully protected, like attorney-client. Attorney protected work is. Martin continues, when co-employees' only connection is as an independent witness, that is, they saw what happened. The applicant fell down the ladder. Yeah, at 3 o'clock in the afternoon, I saw them fall down the ladder. And they're not a co-defendant, or they're not a supervisor or a manager or partner, or in some other way a person identified as the individual, a human, to speak for the employer. These co-employee statements are not privileged, even if the defense attorney requested them in preparation for litigation. Witness statements obtained by attorney-directed interview are not automatically protected by the absolute work product rules. So at that point, we just consider the qualified work product. Again, we want the attorney's fingerprints to be all over the thing. We want them to be, if this puppet is the investigator and the strings are being held by the attorney, directing the private investigator or the adjuster as to what to ask. And that will, as a matter of law, be a qualified work product. Statements not covered by the absolute work product. If you want to avoid these issues, as I suggested many times already, have the attorney conduct the interview and or have the attorney give specific express instructions and questions before the interview to the PI or to the adjuster. In fact, I recommend, rather than a conversation, you actually have the attorney write out each and every question and follow-up questions that they want to be asked. And that will obviously demonstrate the attorney's thought processes, thought regarding defenses, and mental wherewithal as to how the case is going. And then you're going to have an absolute protection. And there we are, mental impressions, strategies, legal theories. All right, demand for witness statements. They've demanded your witness statement and you believe it is privileged, then you so advise opposing counsel. You go in front of a judge, they do an in-camera or in-chamber private review, and if you can't demonstrate that they are obtained under the direction of the attorney, you produce them or face sanctions, something none of us want to do. And that, although we just cite the Tristan case here, there are many cases both at the WCAB level and District Court of Appeal level, and I believe California Supreme Court as well, that suggest, or no, that make clear that we can be sanctioned. Then the question only becomes then, if we are ordered to disclose them or required to disclose them, when do we disclose them? After the deposition, before the deposition, before some other discovery activity proceeds, after it? A lot of really good questions. Great questions, none of which we're going to answer today because we've just run out of time. I look forward to talking with you all at our next webinar, and let me send you over to Tammy. Have a great afternoon.